conservatorships, which we may talk a little bit about, but the topic today is wills and trust. So we're gonna start with that. I've tried to key this to the beginning to some kind of scenarios, some examples to explain kind of what a will is, who needs a will, what kind of situations you might encounter, and briefly descriptions of different kinds of planning things you could do to address a few different situations. I hope that we can also get to a little bit beyond wills and trust into some other planning issues that are also important, but we'll see how far we get. So the first question, and I guess you're thinking about this if you decided to sign up for this session, is, are you a person that actually needs a will or a revocable living trust? You hear a lot of marketing about people needing a trust. It's kind of a catchphrase, but not everybody really needs a trust. But as far as who might need a will or a revocable living trust, if you don't have a will, your property is distributed according to statutes. So if you don't have a will, it's not like nothing's going to happen when you die with your property. There's a scheme that's set forth in the statutes to say who's going to get your things, and it's relatives. So for example, if you die and you have a spouse and you have some children, the statute sets forth how much the spouse and the children are going to get. They divide it. A lot of people think that if you're married and you die, all your property automatically goes to your spouse. That's not necessarily the case, because what they call the intestacy statutes set forth who gets your stuff, and the children are included. The children would have a share of your things. If you were married, it wouldn't all automatically go to your spouse. So if you want to distribute it in a way distribute your things in a way that are different from what the statute sets forth, then you might need a will or a trust to set forth that distribution. Another reason that you might want to have a will is that you want to say yourself who the executor is going to be. When someone dies and they're intestate, which is die without a will, any person can go to the court and file a petition to be appointed what they call different terms, a personal representative or an administrator of an estate, and that person would, work with the court to determine what your assets are, determine what your debts are, pay the debts that are valid, and distribute the property. If you want to control who that person is that does those things, you would name that person in your will as an executor. If you don't have a will, the court will appoint somebody that the court thinks is appropriate, but it may not be the person that you wanted. So that's another reason that you might want a will. If you think there's going to be some conflict, obviously, about how your property's handled at your death, you might want to have a will. And then what we're going to talk about ongoing in the next few slides is unintended consequences that might occur if you don't have a will. So what if someone dies and you can't find the will? To probate a will, you're required to have the actual original copy. Courts are one of the last places where electronic things just don't do. A photocopy won't do. You have to have an actual original copy with the original signatures of the person and the witnesses. So if the will is lost, it's presumed to have been revoked, because mom had the will in her possession after she died. Nobody can find anything but a copy. Maybe she burned it. Maybe she tore it up. The law provides that you just assume mom destroyed it, and then you cannot probate that will. So if you make a will, the first thing to note is to have it in safekeeping somewhere, where people know where to find it. If you make a will with our firm, we keep them in a fireproof safe here at the firm. We don't usually give the originals to clients, so then everybody always knows where it is. Some people might want to, they just think they know what they want to do with their property. I'll just handwrite a will. The question is, does that really work? You know, a lot of times if you just write down in your own handwriting what you would want, it may not be worded all that well. It could be incomplete. You don't cover everything. It can be confusing. We would always recommend that you have someone help you write a will so that you cover all your bases. But technically, a handwritten will that's all in your own handwriting and signed by you can be enforceable in Tennessee. It's what's called a holographic will. So it will work as a valid will, but it creates problems. It often creates more time spent in court trying to have it interpreted and try to figure out what the person wanted that does kind of a holographic will, which is what it's called. Having somebody that understands wills and does them all the time and knows what's supposed to be included is usually much better, and that's what we normally recommend, even though technically you can write out how you want your property distributed, who you want your executor to be, and it can be enforced to the extent that it's clear and can be understood. So what could go wrong? If you have no will and no immediate family or descendants, you're going to look at the intestacy statute. So we'll go down to further relatives. You know, it's so spouse, children, and then it goes up to parents, and then after the parents, it would go back down to siblings, and then you get into nieces and nephews and cousins and other people. So if you have no will saying where your property goes, it could go to people you've never met. It also could create some issues because whoever goes to the court and says they want to administer your estate, intestate, will then have the task of trying to find who the heirs are. They may have to hire a firm to search that out and do genealogy and try to figure out who that is. But chances are, if you don't have immediate family and all your family are very extended out to, like I said, cousins or far off relatives, those are likely people you don't even know, and you may have preferred for your property to go to a charity or to some other, a friend or some other place other than just the statutory framework. So that's a consideration to make when you're deciding whether you even want to have a will at all. It would be a good idea possibly to keep a list of your family members with names and addresses, because even if you have a will, that could help an executor later on to find the people to distribute the things to. So that could be a good idea. So what if you don't have a will and you're not married? This is very, very common these days, is for people to live together and not necessarily be married. Tennessee is not a state that recognizes common law marriage. So if you don't have a will and potentially you would want your partner to get your stuff, and that partner is not recognized under the law as a relative at all, the property would not go to that person, it would go to someone else. If the house, like, you could title property jointly to have that property pass to a person that was not your spouse. That would be one planning option, but as far as other things that don't have a specific title that may pass upon death, examples being like joint bank accounts possibly, you could have both names on, or real estate, you're going to need documents to make sure that those things go to the place that you'd like. You can put, for what I was saying, for an example, you could put a house in joint names with a right of survivorship. That would solve that problem, at least with that particular asset, but not necessarily with other items that might be in your estate when you die. And I mentioned this briefly before. If you're married and you don't have a will, a lot of people assume that everything goes to your spouse. That's not necessarily the case. This becomes kind of interesting with second marriages, which we're going to talk about a little bit too, but a lot of people assume that everything goes to your spouse, but the children are actually going to share in that if you don't have a will. So if you want your spouse to get everything, then you're going to need a will to override those laws. So for a second marriage, this happens frequently, especially we have a lot of people later in life marriage, like the first spouse dies and they remarry, or possibly there's been a divorce where each party's been divorced previously and they both have children from other marriages. A lot of times in that instance, people would want their things to go to their children when they die. And they assume that even if they write a will where their items go to their second spouse, that once they die, whatever's left goes back to their children. Well, that's not really the case. I mean, once the property's been distributed to your second spouse, they own all that property. They don't have any obligation to give that to the children, your children from your first marriage. If you want to set forth a scheme where certain things go to children that weren't necessarily of your current marriage, that's something that's going to have to be specifically provided for. So that's another instance in where you would need to override what would normally happen by having a will. The other thing that we do that's not necessarily a will or trust, but just an estate planning tool, and I do this frequently with older people who are getting married for the second time, like perhaps they've been widowed and found new love. So we do a lot of prenuptial agreements that set forth that everybody's property is going to stay their own and waive inheritance rights to their spouse's property. And those are usually solely for the purpose of making sure that the wealth you've accumulated over the years will go to your descendants rather than to the descendants of your second spouse. And a lot of times that's what both spouses want. And so they can protect that wish by entering into a prenuptial agreement with each other. So that is a good planning tool to avoid an instance where everything goes to your spouse, and then if you die first, everything goes to your spouse, and you basically have disinherited your children by leaving your spouse as the first beneficiary under a will. You have to be careful of that. So what happens when another surprise child shows up? You may have an intestate heir that you don't really, that people don't know about. If that person can prove that they're related, they may have never been around, no one ever knew that person, they could take a part of the estate. So if the deceased knew about that child, they could disinherit that child with a will. The deceased could acknowledge that person existed and just leave them nothing. But with no will, any child that shows up and can prove that they are genetically related would be considered an heir under the law and would get a part of the estate. So that's another instance in which you just want, whether you knew about the child or not, to make provisions in your will as to whether that person should share in the estate or should not share in the estate. So there are other things to consider that wouldn't, different types of property that wouldn't necessarily be what we call probate assets, which are things that pass under the will. There are things that pass outside of probate. For example, I mentioned earlier, you might have a joint bank account that's in your name and your spouse's name, say. That account is not going to be considered part of the estate when you die. That account would just be fully owned by the joint owner. And then there are also types of property that have beneficiary designations. So for example, an IRA or a retirement account, you would designate by forms. I'm sure some of you have filled out these forms with your employer for your 401k. You would designate where that retirement account goes when you die. So this is something else to be careful of, because, for example, as it says in this slide, why is my ex-wife receiving my IRA? Well, when you got the job, you were married to that person. You said this wife was going to get this IRA, and then later when you get divorced, if you forget to change that, it's not revoked by the divorce. So you may be giving all your retirement money to somebody that you never intended. So as part of estate planning, we always give recommendations about how different things should be beneficiary designated. Usually retirement accounts, what beneficiaries should be on life insurance policies can be an important part of planning your finances for when you die. So those things all need to be investigated and confirmed that they are going to the right places, to the people that you would want to have those things. So, and then that's something that should be reviewed periodically to make sure that it still matches what you intended. So is a simple will really the best option? One thing that some people don't consider or that should be considered in estate planning is what happens with the person who's receiving your property after your death. For example, what if your spouse after your death becomes ill and needs a nursing home? Should you plan in advance for how the money is going to be handled after your death so that you can try to protect those assets from being spent on long-term care? And this has become an important consideration as the population ages and more people need to go into long-term care. There are tools we can use to protect that money to still be used for the person who's had to go into long-term care without depleting all of the money to pay for that care first. So that is something to be considered when you're planning what kind of special trust might be used instead of a simple will, to plan for that contingency that the beneficiaries of your will may need to use that money, and you don't want it all to just be spent on care. You would rather it be spent on something that would make their life easier and not necessarily just for nursing home expenses. The other important consideration that we see more and more often is people who have a person in their family with a disability or with special needs. And there are tools that you can use so that you can protect money for use for that person to be taken care of, and to not jeopardize government benefits that person may be entitled to receive if you didn't set up your estate planning framework in the correct way to provide for a trust, a special kind of trust for that person to protect those assets for their benefit. That's a situation in which you often could need a trust, which is a much more complicated plan that you'd want to get advice about how to distribute that property to that person who has special needs or special considerations. Who else might not be protected if you had just a simple will with no trust? What if you have a child who would just spend the money? If you have a spendthrift child, possibly a child with a very controlling spouse who might influence that child to spend the money, an outright distribution to the so-called spendthrift child, or the child with someone who may influence them, could be quickly spent and not be available for them to use. In these situations, we could include, you can write the distributions in your will so that that money is protected in different ways, with a trust, possibly to distribute some money now and some money later, or to distribute it according to an age where you think that child or that beneficiary may be responsible enough to handle the money. So that's a situation in which you might need a more complicated will than just a will that says to my spouse, and then if my spouse is not living anymore, to my children. You may want to make provisions for trust to protect that, and also for potentially a beneficiary that has a lot of debt to potentially protect from creditors. Another thing that might be considered in an estate plan that's not necessarily a will is what you do if you own a business. The executor, the administrator of your estate might be able to run the business until the ownership is distributed to the beneficiaries, but you need to consider the fact whether your beneficiaries are able to run that business, and you would need to have a specific succession plan for running that business, particularly if it's a business that has supported your family, and you want the business to keep as an ongoing operation, to continue to produce income for your beneficiaries after your death. Part of your plan should definitely be a succession plan for a business. So what about, we said that one of the reasons that you might want to make a will is to choose your executor. So a lot of people, I hear this all the time, they just think, well, I should appoint my oldest child. That child's the oldest. They should have priority to be appointed. That may not be the best person to appoint. You really want to give careful consideration to who you would appoint as an executor in your will. You want to make sure it's somebody that is responsible, probably somebody that understands finances, somebody that could reduce the conflict or get along with the other people in the family in handling all these business matters and financial matters after your death. And it's not a good idea, although we're glad to help, it's not a good idea to just say, well, I'm going to appoint this person and then we'll leave it to the attorneys to help this person figure it out in the end. Sometimes it's a good idea, if there's a lot of conflict in the family, just to appoint a third party that's unrelated, a neutral person, to handle everything. And those are all things to consider when writing your will, to make sure that you've chosen the right person. And another consideration would be, some people will say, well, I have two children, I want them to serve together. I don't want to pick one over the other. And that can create problems too, if they disagree. So it's important to carefully choose who that person is going to be the executor. So what happens with your debts when you die? If somebody dies owing a lot more than, well, let's start at the beginning. When someone dies and you open an estate for the person to start the process of distributing the property, the first thing that you have to do is publish a notice to the creditors. You have to, first of all, any known creditor that you have, or any creditor the executor knows about, they have to send them a notice that this person has died. And then you publish in the newspaper about the person's death so that any creditor can come forward and make a claim in the estate to try to collect their debt. So if the dead person, which is called the decedent. Under the law, if the decedent had a lot of debt, those debts could potentially, eat up the estate and leave nothing for the beneficiaries of the estate. There are a few planning things you can do if you know that the person, or that you're going to have a lot of debt at your death. Some options might be life insurance, which would generally go directly to the beneficiary outside of the estate. Owning your property with the real property with a right of survivorship, so that at the time of your death it goes directly to usually your spouse. And then another thing that can happen in an estate administration is the spouse does have certain statutory rights to property. They can file certain claims in the estate to ask for surviving spouse benefits, and those surviving spouse benefits, we won't get into all the details of it, but those surviving spouse benefits will take priority over debts, and those things would have to be paid first before any creditors will be paid. So that all those things might address somebody who has a lot of debt at their death. So if you own a house at your death with a mortgage on the property, how does the mortgage get paid? So if the beneficiaries of the estate are persons other than your spouse, their inheritance will be reduced to pay for the debt on the assets passing to the spouse. But so really the estate is liable for the debt, and the house would, or the spouse would get the house free and clear if there's sufficient assets to pay the debt. If you don't want that to happen, if you want the spouse to pay the mortgage and not, I guess one example would be for a second marriage, that you wanted the spouse to get the house and continue to live in it, but you wanted your children from your previous marriage to get all the rest of the assets. So if you don't want that stuff to be depleted by a debt on the house, and you want your spouse to be liable for the mortgage if the spouse gets the house, you need to put that in your will. So what about joint bank accounts? A lot of people, especially people who get older, will decide to put one of their children, add one of their children to their bank accounts so that that person can help them manage their bills and things like that. This is not necessarily a good idea. The way that joint bank accounts work is that that money would not become part of the estate when you died. That money just automatically goes to the person that's the joint owner of the account. So say you have 3 children, but you have one responsible child. So I'm the responsible child in my parents' family. And they say, Rebecca, we're going to add you to our bank accounts. We're going to give you all our bills. You can pay our bills out of our bank account. They think, obviously, Rebecca knows that what I want is for Rebecca and Christopher and Andrew, who are my brothers, to get their share of the account when we die. But say that I'm not as responsible as my parents think I am, and I don't necessarily feel like I should do that. Once they die, under the law, and as far as the bank is concerned, all the money in their account's mine, and I don't have to share it with anybody. So a better option than adding somebody to an account, if you're doing it for the purpose of assistance, like I'm explaining, is to do a power of attorney that would give that person some authority to help you write checks, but doesn't necessarily make them an owner of the account. The second issue with adding people to your accounts in the manner that we're talking about is that, say my parents add me to their account, but I go out and have a massive car wreck and somebody gets a huge judgment against me for injuring them in a car accident. So I have a large debt. That person who won the judgment against me could come after all of my assets. And now that my name's been added to my parents' account and all their money is part of what's available to pay off that judgment. And that is something that people don't always consider when they're just trying to do things like this for convenience and to handle day-to-day things. They don't consider the unintended consequences of how they've titled things. We've talked a little bit about trusts. One benefit of a trust is that you can keep some of your information confidential after you die. So probate or anything filed with the court is generally public record. So if you don't want inventories of your assets and other financial information to possibly be part of a public record, one thing you can do is to use a trust and have a will that goes into a trust or that puts all the assets into a trust, and the trust would not become part of the public record. So if you have privacy concerns, that may be something to consider in your planning. So when, and this is a little bit of a minor issue, but when someone dies and you sell, you start selling the property and distributing the property, a lot of people, their biggest asset's a house, and so or maybe their only asset, they sell the house, and then they wonder, why do I not have access to this money? For a full probate with notice to creditors like we were talking about, a lot of times the title company will hold, you could sell the house shortly after the death, but the title company may hold the proceeds for a year until the final deadline for claims for the debts has passed. So that's just something to be aware of. I'm not sure how much time we have to get into something beyond wills and trusts. If you would tell me where we are, if we need to have time for questions.
Yeah, so it's about 5:15. So, I mean, this ends in 15 minutes. So if you want to talk about it a little bit longer, or we can transition to questions, it's up to you.
Well, I mean, I think you had said 15 minutes for questions. I could talk a little bit about powers of attorney and healthcare directives, or I can answer questions about wills and trusts.
Either way.
If anybody in the group has an opinion about that.
Yeah,
I have a question about a conservator. What is a conservator? What is a power of attorney? And what is health care? The last one you just said. Like, what's the difference between the three?
Okay, so I have a few things about that. If that's, I can flip through these really quickly if there's some interest in that. So what I think a lot of times is more important than a will or a trust is what we call incapacity documents. And those are financial powers of attorney and also healthcare directives, or a lot of people will call it a healthcare power of attorney. So those are incapacity documents. The first thing and I'm going to go through this real quickly. The first thing would be a financial power of attorney, and that is a document that appoints somebody to be your agent that can manage your finances and your business affairs. So that can become important if something happens to you and you lack capacity to, say, manage your finances from day to day. Even if, say, you're hospitalized and you can't do it, if you, for even a brief period of time that may pass, if you have a power of attorney that appoints somebody, that person could be able to at least write checks for you and do those sort of financial things while you don't have capacity to do it yourself. So we usually recommend a financial power of attorney that is effective immediately. You'll hear about a springing power of attorney that only takes effect when you're actually incapacitated. We usually don't recommend that because you have to prove the person's disabled before you can use it. So that's a financial power of attorney. So a lot of people confuse an executor with a power of attorney, or an attorney in fact is what you call an agent or a power of attorney. So just quickly, if you're an executor of an estate, if you're appointed executor of an estate, you have no authority to do anything while that person is alive. If you're appointed an attorney in fact under a power of attorney, you have no authority to do anything for that person once they're dead. That's only while the person's living that you would have authority. So there's several things you can do for healthcare decisions. The standard Tennessee for appointing somebody to make your healthcare decisions is what they call an advance directive for healthcare. There's a standard form for it. You can indicate what sort of conditions you aren't comfortable with living with. Like you can say, if I'm in a permanent unconscious state, or I have a terminal illness that has no cure, I don't want I don't want artificial feeding. I don't want to be resuscitated. You can give instructions, but also an advance directive for healthcare would name an agent to make those decisions. So like one of my brothers is a doctor. So my parents may want to name him as their person to make decisions. Those are effective. Those can be effective currently if you're not incapacitated. But of course, if you're sitting in the bed and your agent is saying, I don't want her to get that medicine, and you're saying, I'm going to take that medicine, they're going to listen to you first if you're there, and you can say what you want. But that is advanced directive for healthcare along the lines of a healthcare power of attorney. And I think it's important to have that. In the event that you don't have that, there's orders, we won't get into this, but there's orders that can be signed by a doctor. They're called a post, where they will just sign orders on what should happen. And then I don't know what her name was. The lady asked about conservators. Surrogates, guardians, and conservators are what happen when you don't appoint a financial power of attorney and you don't do a directive for health care. So a surrogate, just quickly, is when it's under a statute, a doctor, nobody's been appointed, the person lacks capacity to make their own decisions, nobody's acting in their best interest. The doctor looks around the room and says, who seems to be trying to act in the best interest of this person the most? And they can, there's a statutory form they can sign to say, this is the person we're going to listen to about this person. Of course, you didn't pick that person, so that's something you really want to avoid. A conservatorship is a person that is appointed by the court to make financial decisions or to make healthcare decisions for a person who lacks capacity to do it themselves. This is what you're trying to avoid when you sign your own powers of attorney and healthcare directives, because this gets expensive because you have to file a petition with the court. We won't go through all this, but sometimes you would do this just because to say a person who's had a childhood disability maybe turns 18 and really has legal authority to make their own decisions, but shouldn't be making their own decisions, you'd have somebody appointed. But in the instance where you just never appointed a power of attorney, then your family might have to, they would not be able to access, say, your bank accounts, or would not be able to help you make your healthcare decisions if you weren't able to do so, and they have to go and petition the court and ask the court to appoint somebody, which can be expensive to establish. So that requires, like I said, filing a petition. The person has to have a medical exam. It can be really upsetting to the person because they get served with legal documents like they're being sued. A lot of times the court appoints a guardian ad litem to investigate, which creates extra expense. And then of course there's a hearing, and somebody would be appointed by the court to do that. So that should answer your question about a conservatorship, but I mean, if you have a follow-up question, I'm glad to answer that too. But the conservatorship is basically what happens when you don't plan in advance for those things. So if there are other questions, I'm glad to answer them.
Okay, thank you.
I have a question.
Okay.
Right. What does the state of Tennessee stand on when you have a spouse to die in the hospital and you receive some hospital bills and they want the living spouse to pay the hospital bills for the dead spouse? Well, how does the state of Tennessee stand on that? Because I understand that they said that you're not, if you did not receive the care, you're not really responsible for paying that bill. So I don't know.
Generally, that's probably how it's going to play out, is that's a debt of the person that has died. There is kind of a little known, or I don't know if it's little known or seldom used, common law concept where the hospital might be able to make a claim against the spouse against the spouse for not providing what they call necessaries for the spouse. You don't see that happen a whole lot, but you know, theoretically they could pursue it against the spouse, but it generally would first be a debt of the deceased person as part of the estate.
Thank you.
Got a question. Asked me as his power, and he's a veteran, and he has a lot of medical. And my question is, in the power of his attorney, it's probably similar to the same question she's asking. Me being a sibling, how would that work out for me as far as the doctors? The hospital may try to sue me, or if I'm over his estate.
As a sibling or as an executor?
Yeah, I'm his. It's a power of attorney.
Yeah, I mean, as
legs cut off. So
yeah,
you know,
you're cutting out a little
so
bit.
I don't.
You're cutting out a little bit. I think I understand your question. I think you're asking if you're the power of attorney for somebody, or possibly you're the executor for somebody's estate, if you'd be personally liable for debts that they might have. Is that what you're asking?
Right.
Yeah.
Right.
So all those roles, a power of attorney or an executor, are what we would call a fiduciary responsibility, where you're acting on that person's behalf and you're supposed to act in their best interest. But those, well, I mean, you do have an obligation, like I said, to act in their best interest and not mismanage their money. It doesn't come with an obligation to personally be liable for their debts or their obligations. So
Okay.
you're standing in their shoes to make their decisions and manage their property, but you're not standing in their shoes to be responsible for things they owe, for example.
Okay. That's what I need to know. Thank you.
I think we have time for maybe one more question, and then we're going to need to wrap everything up if anyone has one last question to ask.
What about unclaimed property sites? At what point does something from a deceased show up in unclaimed property reports?
You know, I don't know much about that. We usually always, when we administer an estate, one of the first things we do is check the unclaimed property to see if there's anything out there. Theoretically, if you had an estate like we were talking about at the very beginning, where maybe the person didn't have a lot of immediate family and you were looking out to those far off branches of their tree and you couldn't find the relatives, that money might, if you couldn't identify heirs, it would go to unclaimed property with the state at some point. But like I said, I don't know a whole lot about unclaimed property other than we always check to see if there is any, and that eventually when they can't find anybody, your money just goes back to the state. So you may want a will to say who it should go to if you don't want it to end up with the government in the end, if they can't find anybody you're related to.
Okay, awesome. Well, Rebecca, thank you so much for sharing all your information. Really quick, I'm gonna share a poll really quick. It should show up on your screen. Hopefully can you guys see that poll that I just submitted or sent out? If you wouldn't mind just answering those questions, that way we can get your feedback on this session for Virtual Money School. We'd really appreciate that. And just a reminder, if you do the poll, then you get entered to win AirPods. So a really good incentive there. But yeah, and then once you have done the poll, feel free to leave a meeting. So thanks so much.